They thought I was confused. They thought I was already gone. And I let them think exactly that. My name is Arthur Callaway. I am 68 years old. For 31 years, I worked as a civil engineer for the state of Georgia, designing bridges that still stand today. I know how to build things meant to last. I know how to lay foundations that nobody can see but everything depends on. I also know, better than most, that the most dangerous cracks are the ones that form slowly, quietly, deep inside the structure, long before anything shows on the surface. My wife, Margaret, passed 6 years ago. Pancreatic cancer. 12 weeks from diagnosis to the day I sat alone in our bedroom, holding her hand as she left. We had built a good life together in Savannah, a 4-bedroom house on Habersham Street, 2 rental properties on the east side, a modest investment portfolio that I had tended carefully for decades, and a savings account that Margaret and I had never once touched because we agreed it was for emergencies only. When she died, everything passed to me. That was what our estate plan said. That was what we had agreed on together, sitting across from our attorney back in 2003. We had 2 children. My son Daniel was 41. My daughter Patricia was 38. I loved them both. The way you love something you built from nothing, something that carries pieces of you forward into the world. I was proud of them. I had paid for their colleges, helped with down payments on their first homes, loaned Daniel money twice without ever asking for it back. I did these things not to be repaid, but because that is what fathers do, or so I believed. The first sign came about 8 months after Margaret's funeral. Patricia called me on a Tuesday evening, which was unusual because Patricia and I spoke on Sundays. She asked me how I was feeling. She asked whether I had been forgetting things. She mentioned, very casually, that her neighbor's father had recently been diagnosed with early-onset dementia, and that the family had not caught it in time. She said it in a gentle voice. The kind of voice that sounds like concern but lands like a suggestion. I said I was fine. She said, of course. Of course. She just wanted to make sure. 2 weeks later, Daniel drove up from Jacksonville for the weekend. He took me to dinner at a place I had never been, ordered for both of us before I had finished reading the menu, and spent most of the meal asking me questions. Small questions. At first, what did I have for breakfast? What day was Margaret's birthday? What was the name of the street I grew up on? I answered all of them correctly, and he nodded slowly each time with an expression I did not like. It was the expression of a man collecting information rather than enjoying a conversation with his father. On Sunday morning before he left, he sat across from me at the kitchen table and said he had been thinking. He said that the house was a lot for one person to manage. He said that the rental properties required attention and expertise that might become burdensome. He said that he and Patricia had been talking, and they thought it might make sense, purely for practical reasons, for me to consider signing a durable power of attorney, just so someone could handle things if I ever needed help. I looked at my son across the table where I had fed him breakfast for 18 years. I said I would think about it. What I actually did was call my attorney, a man named Raymond Bowles, the following Monday morning. Raymond had handled our family's legal affairs since 1997. He was 70 himself, sharp as a tack. And when I sat down in his office and told him what Daniel had said, he was quiet for a long moment. Then he asked me a question that changed everything. He asked whether my children had been in contact with him recently. I said, I did not know. Had they? Raymond set down his pen. He told me that 6 weeks earlier, Patricia had called his office, asking about the process for establishing guardianship over an elderly parent. She had not given my name. She had framed it as a general inquiry. But Raymond had recognized her voice because he had known her since she was 9 years old, and he had been troubled enough by the call that he had made a note of it. I drove home that afternoon and sat in Margaret's garden for a long time. I want to be honest about what that felt like. I have stood on bridges during inspections, 300 feet above a river, looking down at moving water, and felt the solid certainty of the structure beneath my feet. That afternoon in the garden, I felt none of that certainty. I felt the ground shifting. I felt my children's voices replaying in my mind, and I found myself reinterpreting every call, every visit, every gentle question in a new and terrible light. It was not the anger that was hard to bear. It was the grief, the specific grief of understanding that people you love have been looking at you and calculating. I decided, sitting in that garden, that I would not be a passive man about this. I called Raymond back the next morning, and I told him I wanted to restructure my estate completely. I told him I wanted to establish an irrevocable trust with an independent trustee, move the investment portfolio, transfer title on the rental properties, and document everything with a level of specificity that would make any legal challenge extremely difficult. I also told him I wanted to have a full cognitive evaluation done by a neurologist of his recommendation, with the results notarized and filed with the court, so that my mental competency at the time of these decisions was a matter of public record. Raymond said that was the smartest thing he had heard in a long time. It took 4 months. During those 4 months, I said nothing to Daniel or Patricia. I continued our Sunday calls. I attended Thanksgiving at Daniel's house and ate his wife Karen's dry turkey and laughed at the right moments. I answered Patricia's gentle questions about whether I had been sleeping well and whether I was keeping up with my medications. I was the father they expected me to be, a little slower than he used to be, a little quieter, a little easier to overlook. Meanwhile, I was meeting with Raymond twice a week. The trust was established in February. I named Raymond's firm as trustee. The trust held the 2 rental properties, the investment portfolio, and a cash reserve I had been quietly building for 2 years. The Habersham Street house remained in my name. My will was rewritten. The cognitive evaluation, administered by Dr. Sylvia Park at Emory, came back entirely clean. I was in the 92nd percentile for executive function in my age group. Dr. Park told me I had the cognitive profile of a man 15 years younger. I thanked her and asked her to notarize 3 copies of the report. In March, Daniel called and said he and Patricia had found an elder law attorney they wanted me to meet with, just to have a conversation. No pressure. I said that sounded fine. We met on a Thursday at a conference room in a building downtown. The attorney's name was Gerald Fitch. He was in his 50s, well-dressed, and he shook my hand with the particular firmness of a man who has decided before entering the room how the conversation will go. Patricia sat to my left. Daniel sat to my right. Karen, Daniel's wife, sat at the end of the table and did not speak much but watched everything. Gerald Fitch explained, very professionally, that many families in my situation found it helpful to consolidate decision-making authority. He used the phrase, "protect your legacy." He had documents prepared, a power of attorney that would give Daniel and Patricia joint authority over my financial affairs, a healthcare directive that named Karen as my medical proxy, and a letter of intent, already written out, that would formalize an arrangement for them to take over management of my assets. He slid the documents across the table toward me. Patricia put her hand over mine and said, "Dad, we just want to take care of you." I looked down at the documents. I looked at my daughter's hand on mine. I looked at my son, who was watching me with an expression of careful patience. The way you watch an animal you are trying not to startle. I said I needed to use the restroom. In the restroom, I called Raymond. I told him where I was and what was on the table. He said 3 words: "Do not sign." I came back to the conference room, sat down, and told Gerald Fitch and my children that I appreciated their concern and that I would review the documents with my own attorney before making any decisions. Daniel's face changed in a way I will not forget. He said he thought we had moved past the point of needing to involve outside parties. He said this was a family matter. He said, and I'm quoting him exactly because I wrote it down in my car afterward, "Dad, you can barely manage the property taxes on time. You think an attorney is going to handle this better than your own family?" I was quiet for a moment. Then I said, "I'll be in touch." I did not hear from either of my children for 11 days. That silence told me more than anything Gerald Fitch had said. On the 12th day, I received a certified letter from Fitch's office, informing me that Daniel and Patricia had filed a petition for guardianship in Chatham County Probate Court. The petition stated that I showed signs of cognitive decline, that I had failed to maintain my properties appropriately, that I had made several financial decisions in recent months that suggested impaired judgment, and that it was in my best interest to have a guardian appointed to manage my affairs. They had also, I later learned, contacted two of my neighbors, both of whom were approached by Patricia, and asked whether they had noticed me behaving strangely. I sat with that letter for a long time. Then I called Raymond and told him it was time. What Daniel and Patricia did not know was that from the day I left Fitch's conference room, every conversation I had with either of them was being documented. Not secretly recorded, I want to be precise about that. I documented them myself, in writing, immediately after each interaction, with time, date, and verbatim quotes to the best of my ability. I had also, at Raymond's suggestion, sent a certified letter to both children 3 weeks prior before any of this became public, clearly stating my wishes regarding my estate and my competency. That letter had been signed, notarized, witnessed by 2 independent parties, and a sealed copy had been deposited with the probate court clerk. They filed their petition without knowing a response was already waiting for them inside the courthouse. The hearing was set for a Monday morning in late April. I arrived 45 minutes early. I wore my navy suit, the one Margaret had bought me for our 25th anniversary. I had it dry cleaned. I polished my shoes. Raymond met me on the courthouse steps, and we walked in together. Daniel and Patricia arrived with Gerald Fitch and Karen. Patricia was wearing a gray dress, and she looked surprised to see me standing straight and composed. Daniel looked at my suit and then quickly looked away. The courtroom was not large. Judge Loretta Simmons presided. She was in her early 60s, with the unhurried manner of someone who has heard every version of every human conflict and is not easily surprised by any of them. Gerald Fitch presented his case first. He submitted affidavits from 2 of my neighbors who, I noticed, had signed statements that were thin on specifics and heavy on vague impressions. He submitted a list of what he called financial irregularities, which turned out to be the trust transfers I had made, reframed as evidence of impaired judgment. He presented a statement from a physician who had never examined me and whose opinion was based entirely on information provided by Daniel. He spoke for about 40 minutes. He was smooth. He was professional. He looked at me twice during his presentation with the same expression Gerald Fitch had used when he slid those documents across the table. The expression of a man who believes the outcome is already settled. Patricia testified. She cried. She said she was worried about me. She said she had noticed me repeating myself during phone calls, forgetting names, seeming confused. She said she was doing this out of love. Daniel testified. He was calm and deliberate. He mentioned the property taxes twice. He mentioned that I had not responded promptly to several emails. He said, with what appeared to be great sadness, that the father he knew would not have isolated himself from his family the way I had done in recent months. The courtroom was quiet. Judge Simmons looked at me and asked whether I was represented by counsel. Raymond stood up. The judge then asked if we were prepared to respond. Raymond said yes, and he handed the bailiff a manila envelope. He asked that it be entered into evidence. He told the judge that the envelope contained a sealed copy of a document that had been deposited with the court clerk's office 61 days ago, well before the guardianship petition had been filed, and that the seal on the envelope would confirm it had not been opened or altered. Gerald Fitch asked what the document contained. Raymond said, "Let the judge read it and find out." Judge Simmons broke the seal herself. She read in silence for about 2 minutes. The courtroom was completely still. I watched Patricia watching the judge's face. I watched Daniel's jaw tighten. Karen stared at the table. Then Judge Simmons set the document down. She looked up. She looked at Gerald Fitch. She looked at Daniel and Patricia. And she said, in a tone that carried no warmth whatsoever, "Counsel, would you like to tell me why your clients filed a guardianship petition against a man whose complete estate restructuring was already a matter of court record before this petition was submitted, and who possesses a notarized neurological evaluation, placing him in the 92nd percentile for cognitive function in his age group. Gerald Fitch was very still. The document in that envelope was not just my letter stating my wishes. It was the full package: the trust documents, the property transfers, the cognitive evaluation, and a 4-page summary, written by me in plain language, explaining exactly what had happened from the day Patricia first called, asking about dementia, to the day Daniel sat across from me at my kitchen table, asking what I had for breakfast, to the day I was handed a stack of documents in a downtown conference room and asked to sign away control of everything I had built over a lifetime. It was all there, dated, documented, signed, and notarized. Judge Simmons asked Daniel directly whether he had been aware that his father had an independent cognitive evaluation on file with the court. Daniel said he had not. She asked whether he had been aware that the asset transfers Fitch had characterized as evidence of impaired judgment had in fact been reviewed and executed by a licensed attorney over a 4-month period. He said he had not known the full details. The judge was quiet for a moment in the way that judges are quiet when they are deciding how much of what they are thinking they intend to say out loud. She said that the petition showed no credible evidence of cognitive impairment and that the medical opinion submitted was inadmissible, given that the physician had no direct contact with the subject. She said the financial transactions cited as irregularities were in fact evidence of careful and deliberate estate planning. She said that before she dismissed the petition, she had one additional question. She asked Raymond whether his client wished to pursue any counterclaims. Raymond looked at me. I nodded once. What followed took another 3 hours, and I will spare the technical details. Raymond had prepared a civil complaint documenting what he characterized, precisely and with citations, as an attempt to obtain financial control over a competent adult through misrepresentation to the court. The neighbor affidavits, it turned out, had been gathered through a process that Raymond's investigator had documented. Patricia had visited both neighbors on the same afternoon, within 30 minutes of each other, and had provided them with a written list of behaviors to confirm before they signed anything. One of the neighbors, when contacted by Raymond's office, had expressed significant discomfort about the whole thing. Gerald Fitch requested a recess. During the recess, I stood in the hallway and looked out a window at the street below. I was not thinking about the hearing. I was thinking about a Sunday morning when Daniel was 11 years old and we drove out to Tybee Island before dawn to watch the sunrise, just the two of us. And he fell asleep on my shoulder in the car on the way back. I was thinking about the afternoon Patricia graduated from the University of Georgia, and I cried in the parking lot afterward, where she could not see me because I was so proud I did not know what to do with it. I thought about those things, and I let myself feel the full weight of what had happened between then and now. Then the recess ended, and I walked back inside. By 3 p.m, the guardianship petition had been dismissed with prejudice. Judge Simmons issued a written finding that the petition had been filed without reasonable factual basis, and that the cognitive evaluation and estate documentation submitted by the respondent were both entirely valid and entirely sufficient. She referred the matter of the neighbor affidavits to the court's Bar Oversight Committee for review of the conduct of the petitioner's attorney. Gerald Fitch, I later heard, did not speak to Daniel or Patricia on the courthouse steps. The civil complaint was settled 4 months later. I will not discuss the terms, except to say that Raymond told me the settlement was, in his word, significant. I did not celebrate. That is not something I felt. What I felt, driving home that evening on the highway with the windows down and the Georgia air coming through warm and heavy, was something closer to a very deep quiet. The kind of quiet that comes not from winning but from no longer having to hold something tightly. I have not spoken to Daniel since the hearing. Patricia wrote me a letter about 2 months afterward. It was 3 pages long. I read it twice. I have not yet decided what to do with it. What I have decided is this. I am 68 years old. I have my health, my house on Habersham Street, my garden, and my work. I still consult part-time for a firm that does infrastructure assessment. Last spring, I volunteered to review the structural plans for a pedestrian bridge. A local nonprofit was building over a creek in a park on the south side of the city. I spent 4 Saturday mornings on that project, and I was there the day they opened it, standing back from the crowd, watching kids run across it. It held. That is the thing about a structure built correctly from the beginning. You do not have to worry about it. You lay the foundation right. You use the right materials. You do not cut corners because you are in a hurry or because someone is pressuring you. And then you step back and let the thing stand on its own. The load comes, the weight comes, the years come, and if you built it honestly, it holds. I built my life that way. I built my estate that way. And when the pressure came, and the weight came, and the people I least expected tried to tell me the structure was failing, it held. I want to be clear about one thing before I finish, because I know some of you listening to this have families of your own, and I know some of you are in situations that rhyme with mine in ways that are uncomfortable to sit with. I did not do any of this out of anger. I did not plan those 4 months with Raymond because I wanted to punish my children. Because I understand that the time to reinforce a structure is before the stress event, not during it. Because a man who waits until the load arrives to wonder whether his foundation is solid is a man who has already made his most important mistake. If you are watching this, and you have assets, and you have family, and you have noticed conversations that make you feel like a problem to be managed rather than a person to be loved, pay attention to that feeling. Do not dismiss it because the people involved are people you love. Love and calculation are not mutually exclusive. I know that now. I wish I had learned it more gently. My name is Arthur Callaway. I am 68 years old. I built things meant to last, and I am still here.